Good day to everyone, especially to our professor, Dr. Manuel Roman. Welcome to our subject, the EM216, Personnel Management and Development. I am Christian Vincent Galolo, and I am going to discuss the sections 23 to 30 of the revised procedures of Department of Education in administrative cases. Let's begin with the section 23, the pre-hearing conference. The hearing officer shall conduct a pre-hearing conference for the parties at the commencement of the formal investigation. Parties have to appear, consider, and agree on any of the following: submission of the case for resolution based on position, papers, memoranda of the parties without any need for further hearings. Second, stipulation of facts. Third, simplification of issues. Fourth, waiver of objections to admissibility of evidence. Fifth, limiting the number of witnesses and their name. Next, dates of subsequent hearings. And lastly, such other matters as may aid in the prompt and just resolutions of the case. The next section is section 24, appearance of parties. The parties, together with their counsels, should observe their responsibility in appearing to the scheduled pre-hearing conference. The non-appearance of a party may be excused only if a valid cause is shown therefor. Section 25. Effect of failure to appear during the pre-hearing conference. Failure of any or both parties to appear at the scheduled pre-hearing conference is not necessarily a cause for the dismissal of the case. A party who appears may be allowed to present his evidence in the absence of the adverse party who was duly notified of the pre-hearing conference. However, if the absent party is able to show that there is a valid cause for his absence, he shall be afforded the opportunity to cross-examine the witness presented during his absence. The next section is section 26, record of the pre-hearing conference. The proceedings in the pre-hearing conference shall be recorded. Upon termination thereof, the formal investigating committee shall issue an order which shall recite in detail the matters taken up in the conference and the agreements or admissions made by the parties as to any of the matters considered. Section 27. The non-litigious in nature of the formal investigation proceeding. The conduct of the formal investigation shall be non-litigious in nature, subject to the requirements of due process in administrative cases. The technicalities of law, procedure, and evidence shall not strictly apply thereto. The formal investigating committee may avail itself of all reasonable means to ascertain speedily the facts of the case. The committee shall take full control of the proceedings, with proper regard to the right of the parties to due process, and shall limit the presentation of evidence to matters relevant to the issues before the committee necessary for a just and speedy disposition of the case. Next is section 28, continuous hearing until terminated, postponement. Failure of any or both parties to appear at the scheduled hearings are not necessarily a cause for the dismissal of the complaint. A party who appears may be allowed to present his evidence in the absence of the adverse party who was duly notified of the hearing. However, if the absent party is able to show that there is a valid cause for his absence, he shall be afforded the opportunity to submit written interrogatories to be answered by the witnesses presented during his absence. In case of two successive, unjustified non-appearances of any party in the proceedings, it shall be the option of the party who is present to submit the case for resolution on the basis of the records of the case and the evidence so far presented. Section 29. The adequate time to prepare defense. In scheduling hearings, the committee shall ensure that respondent be given adequate time for the preparation of his defense. And lastly, Section 30, the affidavit of witnesses. The affidavit of any witness shall constitute his direct testimony subject to written interrogatories to be submitted in advance by the proponent and to be answered by the witness before the committee. Only affidavits which have been identified by the affiants shall be considered as evidence. That concludes my discussion about the Section 23 to 30 of the Revised Procedures of Department of Education in Administrative Cases. Again, this is Christian Vincent L. Galolo. Thank you for watching and listening. Enjoy the rest of the day and keep safe.